Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. In this edition is the nuts and bolts of elder law. It's a program for attorneys on handling the wills and estate administration in the office, and it's part of a program sponsored by the New Jersey Institute for Continuing Legal Education. Let's see. Now, typically the phone rings. Legal assistant answers the phone. That's a good ring because it's a ring for someone who needs help. And person needs some advice, needs documents. So, oftentimes, what's the first question that someone asks? Let's see, how much? Well, how much really depends upon the size of the estate and how much work is involved. Let's say if someone just wants a $45 will, well, that's usually not something that's cost effective for the attorney to get involved in. Attorneys should either do something right or not do it at all. Let's say there are also some people that they just they want the cheapest thing possible, and that's not the right way to go. Well, people have questions, and that's what as attorneys we do. We answer questions, we solve problems, but typically it's a fee for the service, and most attorneys nowadays don't provide free consults unless it's a personal injury case. Let's see, if someone wants consultations, they should be prepared to pay and get good advice. Let's see, if they want to just do research on their own, they can do research on their own. So, someone calls the law office, calls my law office or any law office, then it's a good idea to say send out a will questionnaire. I'd say in my office we have a questionnaire and ask questions, you know, um, regarding their assets. But there's also a cover letter. And the cover letter says, okay, the appointment is for a specific day, specific time. They should bring with you the completed form, and also obviously bring in, credit card in which to pay for the service. Now, what what are some of the things that are filled out by the clients? Well, in our confidential questionnaire, there are simple things. Let's see, what's the person's name? Let's say, where do they live? Let's say, are they married? Or we ask the question now, is there a domestic partner or civil union? Let's see, telephone numbers, who are they referred by? The person referred. Is it a client or another attorney? So that we can at least send a thank you letter ahead of time. In our form, we also recommend a durable power of attorney. Let's see, and we put on the form that we recommend it. Let's say we also ask questions such as, we recommend a living will. Do you want it? Let's say sometimes when a family member calls during an illness, let's say, and they said, do we do a power of attorney, and we already did the will, we check and see the file, and whether the person, sometimes the person, no, I don't want it, and they don't want to pay for it. Well, we can't, an attorney, we can't force anyone to do anything. Let's see, page 2. What are the other questions that we ask? Well, let's say the line says, what questions do you have? Let's say, and we want it to be filled out in that person's handwriting. Let's say if we said, okay, executors. Who do you want to be the executor? Now, what's the executor? The executor is the person that carries out the duties after the person passes away. Make sure that the bills are paid, that the assets are marshaled, fills out the appropriate tax forms, takes care of selling assets, selling the house, and then eventually doing the job to either get a court approval for the distribution or preparing release and refunding bonds so that everyone can sign off on the work. So, is the person I asked the person, is the person you picked as the executor able to do the job or want to do the job? They don't need to have a degree from a good college like the University of Scranton. They just need to be able to balance a checkbook and bring in other smart people. We typically don't recommend joint executors because that's sometimes a way to create fights. Let's say there's a reason why there's not two presidents and two governors at the same time. Our form then asks questions such as assets. Now, let's say we stopped sending out detailed questionnaires because that would scare away some people, and some of the older clients weren't able to, they had difficulty filling out. So, I'd say, I'd say we we ask questions such as your house, where is it at, and what's the approximate value. Let's see, are there any mortgages on it? What are the real estate does the person own? Let's say bank accounts, stocks, CDs, other assets, approximate amount. Uh, who are the beneficiaries of the bank account? We say if none, write none. Now it's important to explain to the clients that certain assets don't get passed through the will. They have direct beneficiaries by contract or by law. A house, for example, two married people usually own it, husband and wife. We explain to them joint bank. If someone sets up a joint bank account, that's a contract that automatically goes to the survivor. So if Ann Hattie has a joint bank account and she put down that it's joint with with Shannon, just because Shannon lives nearby and helps her out, when she passes away, Shannon's getting that. Other assets, you have to explain to the clients. That's important. Assets that pass by contract if you're a beneficiary. IRA, 401k, life insurance, annuity, pension plans. Anything that sets forth the beneficiary, that person gets it. We also ask for the approximate amount of life insurance because for the purposes of federal, state, and gift taxes, life insurance is covered. That's it. And then the next question is the big question that's on the form. Who's beneficiary 1? Who's beneficiary 2? Who's beneficiary 3? Now, I want the form in my office to be filled out by the client. I'd say, because who is the client? The client has to be the person who the document is being prepared for. The client is not the son or daughter that brought the person in, and I want the fees to be paid by the person. Let's see. We also ask questions such as, are there any specific bequests of money or property? Because it's not sufficient for someone to say, to the whole family during the holidays, I want my granddaughter Shannon to get all the assets. It has to be in the four corners of the document or a codicil. And for the same thing, in addition to specific bequests, is there anyone that you don't want to get? Let's say, and we usually be specific as to the person's name. I leave no bequest for X person. We don't leave them $1 because then they're included, possibly included in the accounting. Just nothing to, and then we don't put a reason. If we also ask for, if they have minor children, because that's important, because we don't want 18, 19-year-olds getting any assets. Typically, minors are not good with money. Typically, if a college kid inherited money, they would not invest it wisely. They'd go and buy a red fast car and then go down to the beach and spend the rest of the money. Next question, set of questions asked, if there are minor children, I'd say, who would be the guardian? I'd say who would be the trustee? Now, the guardian's the person who holds the children. The trustee is the one who holds the money. Sometimes they're the same. Sometimes they're different. And for many clients that have minor children, that's tougher than deciding, who's going to get it or the executor, because they said, well, there's no right person. And of course, there's no right person. So we ask the question, who don't you want to raise your child? Sometimes they have difficulty deciding. I'll ask the question, if you can't leave this room right now, who do you want to watch your children for the rest of the day? And they, oftentimes they'll pick a parent. So say, okay, that's the person now. You can do a codicil and change it in another year. We also ask the question, do any of the beneficiaries have special needs, or are they receiving SSI or SDD that they might need a special needs trust? And of course, we ask the question again in several locations, what questions you have here, what questions you have here. Because answering questions is what we do, and we want the client to know that we're in a position to answer their questions and help them out. It's a time to make decisions. Let's say many of the clients said, well, I'm not sure, I'll get back to you. Well, people need encouragement, a call to action. And I had a friend of mine that, you know, I did a house closing for him in 1999. And every time I saw him, every month afterwards, he'd say, yeah, I got to get around to getting that will. I got to get around to getting that will. Well, in it's September of 2011, he worked in the World Trade Center for Morgan Stanley. And the day after 9/11, my office got a call from the gent. He goes, well, I'd say, I think it's time to do a will. And I said, I think it's time for you also coming Thursday. And he goes, well, I'm kind of busy. He goes, busy doing what? You have no office anymore. Let's see. So, again, a call to action. What we do is we email out the questionnaire to the client. Let's see, let them fill it out. And this way they're not just in a haste filling out things in the office. So we got our appointment letter. We've sent out the questionnaire, and typically we tell the person, okay, the fee is X amount, and it includes, for most people they want 6 different documents. Wills, of course, there's separate wills for husband and wife, power of attorney for each of them, and living wills. Let's see. Typically, most people in New Jersey don't need a trust because New Jersey is a probate-friendly state and a probate-easy state. We accept credit cards in our office: Visa, MasterCard, American Express, even Discover, and that's how we handle our cases. Let's see. Once the documents are, once we're paid, we draft the documents and we include in a letter to the client saying, okay, here's the draft to the will. Please read the document carefully. If there's any changes, amendments, corrections, take a pen, mark up the draft, and get it back to our office prior to the day of signing. Someone can mail it to us. They can fax it to us. They can slip it through our mail slot. They can scan it and send us a PDF. We don't accept phone calls that say change things because we got to be satisfied that's the client, and things get lost over the translation. Not the translation of different languages, but sometimes in phone messages. And we also want to make sure that that's what the person wants. Now, I'm going to touch briefly upon the ethics. And ethics mean who filled out the form. I'd say, because I want the form to be in my client's handwriting. So we have to be aware of conflicts of interest. Let's say, is there potential undue influence, duress? Let's say, and we also give brochures to our clients that are available on our website. Let's see. I mentioned the will bill because the rules of professional conduct, rule 1.5b, indicates fees shall be in writing. And the way my office and most attorneys work, we don't do the work until we're paid. We also, when someone's sitting there, we schedule a date to sign. Let's say, some people want to think about it, and that becomes a problem. It goes, well, listen, we're going to schedule it for 2 weeks, 3 weeks, and that's when we sign. And in our next edition, I'm going to talk a little bit about the power of attorney and the will signing. And for other information regarding wills and the preparation of this types of estate planning, you can visit our website, njlaws.com. That's njlaws.com, or the Central Jersey Elder Law website, or call the law office of Kenneth Vercammen, 732-572-0500. We're located at 2053 Woodbridge Avenue, Edison, New Jersey. Thank you, and good luck.